Hey everybody, I'm Lloyd Chatfield and this is the Business Law Bootcamp. Today we're going to talk about supply agreements. But first, our standard disclaimer. This video is for informational purposes only, does not create an attorney-client relationship, and does not constitute legal advice in any jurisdiction. Alternatively, your sole and exclusive remedy for any and all claims arising out of your use of this video shall be a full refund of the money you didn't pay to watch it. So, supply agreements. Generally speaking, supply agreements for our purposes means contracts for the sale of goods between two companies. They can be called sales agreements, purchase agreements, etc., but that is the basic concept. In my experience, 90% of the issues that arise in supply agreements deal with one or more of five primary issues: quantity, term, price, warranty, and liability. So let's talk about each of those. First, what is the quantity you're selling? Sometimes this is very simple. 100 widgets is 100 widgets. But the parties can also agree the quantity is to be determined. In that case, it's important to define who decides how much and to what extent the other party is obliged to buy or sell that quantity of products. Two quantity terms you should understand are requirements contracts and output contracts. With a requirements contract, the parties agree that the quantity will be the amount the buyer needs over time. With an output contract, the quantity is literally as much as the seller can produce. Related to this is the concept of exclusivity, which can provide that the seller can't sell the product to anyone else, or the buyer can't buy the product from anyone else. Although exclusivity is usually okay, there are circumstances when exclusive dealing like this one can be considered a violation of competition laws, i.e. antitrust. So exclusivity is an issue that warrants some legal analysis. Price is the issue parties usually haggle over the most. Price is usually very simple. $1 per sprocket is not subject to much ambiguity. But with long-term contracts, you need to understand if pricing is firm or subject to change over time. Parties can agree on how and when price can be adjusted, but for the buyer, the key is to be able to walk away if the seller gets too greedy with pricing. Two special pricing terms you should be aware of are most favored nations and lower competitive price clauses. With most favored nations, or MFN pricing, the seller agrees that the buyer will get the best price offered to anyone. Sellers need to be very careful granting MFN pricing because a one-off discount sale could unexpectedly put you in breach of your MFN customer. For a seller, an MFN should be granted only to your best customers, and the terms of the MFN are critical. With a lower competitive price clause, if a buyer finds a better price from a third party, the buyer is free to buy from that party and is released from the obligation to buy from the seller. MFN and lower competitive price clauses should be used with great care, and it's always best to work with counsel to ensure you structure those appropriately. The term of the contract is often critical. Let's say you found a company, Acme Pulp, to supply printer paper. You agree on a great price for 100 reams per month. You sign the contract and things go great. But 13 months later, you go paperless, or you find a new supplier. You email Acme that you don't need their paper anymore. Then Acme refers you to the term language in the boilerplate contract you signed, which said you have a 1-year term that automatically renews each year if not canceled. This happens all the time, and there are companies, particularly in the office services and supply business, that trap unwary customers with auto renewals all the time. This is one of my great pet peeves, and I implore you, especially when you are the buyer, never, ever agree to automatic renewals. You want to make an affirmative decision to renew, not be stuck with another year with a vendor you've grown tired of. A 1-year term is commitment enough, and you should always have the right to terminate on 30 days' notice, period. I repeat, do not accept auto renewals ever. Another part of the term issue is termination. Again, my general view here is that in most circumstances, both parties should be free to terminate at any time, with a reasonable amount of notice, say 30 or 90 days. The only time you should accept a non-cancelable contract is where one party has to make commitments, such as buying raw materials or hiring labor, that they can't do without a commitment. But the point is, there are a lot of fish in the sea, and in business, maintaining the flexibility to change suppliers is critical. But whatever you take away from this, remember, no automatic renewals. Warranty is always a critical contract term. As a seller, you need to be very clear what warranty you are providing, how long it lasts, and what you'll do if a product fails to meet the warranty. You may be very confident that your widget will widget properly for the rest of time, but as the seller, you need to very carefully define what that is. Sellers also need to understand that sometimes the law implies a warranty. And unless you use the right magic language to exclude implied warranties, a jury of your peers may get to define your warranty for you years after the fact. The final critical term in supply agreements is liability. Savvy companies always place limits on their liability. They explicitly state in their contracts that regardless of what happens, we are not liable for consequential, incidental, punitive damages. They sometimes also place a dollar cap on their potential liability, such as the total purchase price of the contract. Buyers hate that because it means they have some risk, but as a seller, you should always make sure your risk is commensurate with the reward. If you nail down those 5 issues, quantity, price, term, warranty, and liability, you've gone a long way to making sure your supply agreement will work for you. But depending on the circumstances, you may want to address a number of other issues such as delivery terms, choice of law, force majeure, indemnity, and dispute resolution. That stuff is typically included in the boilerplate, and only with truly critical agreements do you ever engage in a lot of negotiation over these. So that's it for supply agreements. And please remember, never, ever agree to an automatic renewal. Thanks for watching the Business Law Bootcamp. We'll see you next time.